Welcome everybody to this deep dive of EU AI Act and EU AI regulations and directives coming to the world actually. So this is one of these wonderful examples like data protection where we had the GDPR coming from Brussels and then going global. And we believe that the same thing might happen soon with the EU AI Act. And I'm so happy to have a very esteemed panel with me of experts doing this day to day in the trenches of their companies, implementing AI and bringing AI to life. So I would start with a 10-minute presentation. I'm actually going to do a little bit of black letter law on the EU AI Act, because I believe this is a good idea to start to lay the foundation of what we're discussing. And then I would like to discuss with my panel how they believe this act coming into the world, coming to India, how it's affecting Indian companies providing services to the EU overseas globally. So with this, I would like to start and move to my... So what I do is, I do a 10 minutes, it's actually going to be a little bit of black letter law. So this morning, at the beginning of this day, we talked a lot about the AI lawmaking for AI in the US, in Europe, in China, all over the place. And why don't we start and discuss what the EU is actually planning. So if you can go one slide forward, please. One more. Okay, here we are. So this is a statement from the rapporteur, which I believe will kind of summarizes what's going to happen in the EU and which will come to the whole world as soon as your services and your products are directed towards the European Union. This is what's going to happen to your legal framework. The AI Act will set the tone worldwide because it's the first of such legislative approaches in the development and governance of artificial intelligence, ensuring that this technology set to radically transform our societies through massive benefits it can offer, evolves and is used in accordance with the European values, democracy, fundamental rights, and the rule of law. I believe this will resonate very well with India, because I believe one of your strong factors of your economy is your very strong rule of law. And I believe that you will all agree with me that anything, AI, digital, whatever it is, it cannot be above the law. It cannot be next to the law. It has to be under the purview of the law. There's no other way. It goes with hate speech. It goes with whatever it is, digital. The law must be catching every element of society, or in my view and the European view, we have not much of society left. If one area is outside the law, everybody else, any other area can claim the same benefits to them, because we all know that compliance is also costly. Compliance is a requirement that every company will honor, but compliance doesn't come for free. So what are the objectives of this AI Act? It's trying to ensure that AI systems, and I'll tell you what AI systems are under the new European law, are safe and legal, that they are the certaintyship to facilitate investments. So the Act wants to facilitate investments in AI. Of course, compliance is a cost factor, and that will probably also kill, and we'll talk about prohibited AI systems. So we also prohibit in the EU some of the systems, but the idea is to foster and enhance investments and certaintyship in AI. It is supposed to enhance governance and effective enforcement, and it also should facilitate the development of a single market, a single European market. We'll also talk about the Brussels effect of this law that I'm just describing to you all. And the Brussels effect is a term coined by a Columbia professor, by Anu Bradford. She's a professor of Columbia, and she wrote a book about the Brussels effect. And this is nothing new. When GDPR came and you adopted your Indian Data Protection Act very soon before, and you saw the effect of the GDPR coming to the world, coming to every corner of the world, and the same will happen with the EU Act. So we can move on one slide. Thank you. Ah, fantastic. Can you use this one? Thank you very much. So let me tell you where we are. In 2021, the EU Commission had a first proposal on this EU AI Act. In June 2023, so 3 months ago, the European Parliament adopted their own negotiation position on the Commission's proposal. And now, what we are doing right now, we're having a trilogue. In Brussels, all affected entities are discussing, the Council, Commission and European Parliament, they are discussing the final state of the EU AI Act. We believe it will come into effect next summer. And why do we believe that? Because next summer, next August, the EU Parliament will be re-elected, and we believe that the EU Parliament wants to push this through before their re-enactment is happening. So we believe this is happening next year. And notice the form of this law. It's a regulation, like GDPR. It's not a directive, it's a regulation. So the European laws differentiate between regulations, which are automatically effective, and directives, which need to be implemented in national law through another legal act of each member state. This AI Act comes in form of a regulation, meaning as soon as the trilogue is finished and the final EU AI Act has been passed, the law is applicable across all member states. So what are the key changes? What is the law trying to do? One, it's trying to define for the first time what is an AI system. It is a positive list of prohibited AI systems. You cannot bring such AI systems to the market. And then what it's doing, it's developing a risk system, high, medium, low risk of AI systems. And the more risky your AI system is, the more regulation comes to you. You have to fulfill a lot of legal requirements coming from the EU AI Act to be able to lawfully operate, sell, implement, change your AI system. And inflation is everywhere. Inflation is also in the fines. If you remember GDPR, 6% worldwide turnover, so now we're at 7%. So if you have a tier 1, there is a tier 1, tier 2, tier 3, and tier 4 breach of the EU AI Act. If you have a tier 1 breach, which means you are implementing a prohibited AI system into the market, you are facing up to 7% of your worldwide turnovers as a fine. If you are not fulfilling the requirements that a high-risk AI system demands from you under the new EU AI Act, you are risking fines up to 6%, 4%, and so forth. And then tier 4, there's certain information obligation that the new law will give to you as an operator, developer of an AI system. And if you're not fulfilling these information obligations, again, you are paying fees, fines up to 2%. Let's quickly look at the AI system definition. Obviously, this is key. Either you are inside this definition and then you're inside the law, or you're outside this definition and you're outside the law. Pretty much like GDPR. Either you're personal data and you're inside GDPR, or you're not personal data and then you're outside the GDPR. So there's a big dispute, and we'll see next summer how the dispute pans out between what the Commission believes AI system should be and what the Parliament believes AI system should be. Obviously, this is very much driven by technology. Even the IT community is not yet clear what AI system really means, but the OECD came up with a definition, and the Parliament is trying to go very closely with the definition of the OECD. They're trying to take a very technical approach of what an AI system is. But we'll definitely see changes to this definition. The definition of AI system will evolve because technology will evolve. This is now the heart of the whole new law. So the law differentiates between what we call an unacceptable risk. So an example of an unacceptable risk is biometric surveillance, emotion recognition, predictive policing. All of that is a so-called unacceptable risk, and therefore you are not allowed to implement, to create such AI systems in Europe, bringing them to the European market. If you do, it's a tier 1 breach, 7% of their worldwide turnover is at stake. Then we have what we call a tier 2, high risk. Example for high risk systems is, for example, AI system to influence voters in political campaigns, AI systems used in recommender systems displayed by social media platforms, designated as very large online platforms under the Digital Services Act. So you can see there's a high risk for political security, for democracy, for fundamental right violation. Because of that, we are giving, under the new law, high-risk AI system developers a huge amount of obligations. They have to first perform a risk management. They have to test their system. They have to have technical tests done. They have to do data training, data mining, data governance. They have to have transparency. They have to have human ownership. They have to also cybersecurity, IT security aspect. All has to be documented. Only if they fulfill all of these requirements and they can show it and give it to the public, and these high-risk AI systems need to be registered with the register in Europe, then can you legally operate your AI system in Europe. And then you have limited risk. The limited risk AI, for example, is generative AI systems like ChatGPT. So it's very limited. You only have to comply with very limited transparency requirements. If you do so, you are absolutely fine. An example for a minimal or no risk, where there's no obligation whatsoever, is a spam filter, AI-enabled video gaming. This is no risk, and therefore even you don't have to have a transparency register. So I'm looking at, or you are looking better, at a study done by Stanford this June. So Stanford looked at all the large AI systems available right now, which are kind of known, some of them are less known, and took the systems and applied the new standard of the parliament. So it's not final, they're still doing the trilogue. But the parliament, the EU parliament, had their own idea of what the act should look like, and they tested these systems against the parliament's view of our new EU AI Act. And you can see OpenAI, Google, Meta score about 50% compliant. But for example, the last one, Alab Alpha, which is a front-running German AI system, is only by nearly 10%. So they have a year to up their game because it is coming. There's no other way. The law will come. If it doesn't come next August, it will come 6-12 months later. It will be immediately applicable across Europe. And whenever a company from the US, from Australia, from India is targeting consumers, users in the EU, this law will apply. Let me just, so this is all about the EU AI Act. So far, we only talk about what are legal operations of AI systems. We have not looked at what happens if you have an AI system, you're running, operating a legal AI system, low risk, no risk, high risk, and you fulfill all the requirements of the new EU AI Act, but still there's a damage. How can a user, consumer, be protected against his damages that he can get from someone else? So there are two directives coming, and they're coming again, same situation. We're in a tripartite dialogue right now. So the first one is a planned EU directive on statutory liability when using AI. This law, in a formal directive, which means national implementation acts will follow first before it gets effective. This law says every member state in Europe have to create a legal framework so that users of AI systems can take recourse against producers, users, manufacturers of such AI systems. And the interesting thing is, the law says we need a fault-based liability regime. So there has to be some kind of fault of the producer of the AI system. You have not fulfilled the obligations under the EU AI Act. You have not fulfilled under any other act that is existing in Europe, something like that. And what it introduces, which is very interesting, is a rebuttable presumption of causality. The European lawmakers believe that AI systems are complicated, and they rightly believe so. And therefore they're saying the poor consumer only knows what is published. For the rest is a black box. So the law says if you as a user can prove that the other party, the manufacturer, implementer of the AI system, is in breach of a duty of care, for example, breach of the EU AI Act, and that this breach is probable, that it caused the damage, Then we shift it around, and now the burden is a deemed causality, and now the other party, the user, producer, has to burden of proof to show that it was some other cause that actually was the cause of the damage. So we're gonna go shift one more gear, my last comment. This is happening too next year. The new EU directive replacing the Product Liability Act. We have an EU Product Liability Act for about 20 years now, but software was not a product under the existing Product Liability Act. Products really meant tangible physical things like cars. Now the new law, again, we're in tripartite discussions. Next summer we expect this to come to fruition. And then once this law is in effect, as you can see now, products will also be software, digital products, digital services, AI systems. And even worse, a product is not just a software, but a product, a new product, is any upgrade to the software as well. So this law will bite you a couple of times in the existence of your software product. It introduces a strict liability, so no fault required, a strict liability regime of liability. So if your digital product, your AI system, your digital service is causing damages to the consumer does not have to prove that you are at fault for anything. It's a strict liability, like running an atomic energy plant in Europe, strict liability. And again, the burden of proof, it's the same. It shifts the burden of proof as soon as a presumed assumption that if you breached duty of care and the cause could be this could be the cause of the damage, then you as a producer of such AI system have to show that there was some other cause and not you. Otherwise, you are paying for it. Also interesting is, as an expanded definition of damages, loss or corruption of data is also now a damage recoverable under the new EU Product Liability Act. With this, I would like to stop, and I would like to now open the discussion with my esteemed panel and to see how they believe this law that I just outlined will affect you sitting in India or any other company around the globe going forward. So thank you very much. And I'll shift gears. Thank you. So my first question actually goes to Vineet, because he volunteered to ask the first question. Vineet, we talk about the Brussels effect of this new planned EU Act that's coming next year probably. How do you think this affects you and your company Tech Mahindra going forward?
Absolutely. Only I think we are an IT company developing software products, also in research and many other activities. Aside, I think all companies today are in some form or other developing some form of systems which work well. So I personally think all sectorial companies are IT company in their own way. Now, you have the ed tech, you have the fintech, and so on and so forth. So I think every organization today is investing into technology, and artificial technology goes without saying. So that's the first point. The second point is, as a services company, where we are developing artificial intelligence-based systems products, two, partnering with AI, vendors, three, resellers, selling, implementing, etc. So we are connected with AI in some way or the other, and therefore the act impacts us or will impact us surely. Secondly, I think you talked about EU regulations, which obviously will apply to how AI systems will get implemented, etc., in the European Union. But it's global now. So you're doing all similar businesses in the US, India, and wherever. So to my mind, the entire world is sensitive to this piece. In fact, I would like to just maybe refer to one quick statement that the Prime Minister mentioned last night at the BRICS summit, where he says, from India perspective, MeitY, along with NASSCOM, Niti Aayog, and TRI, AI and AI governance framework has already published guidelines, frameworks, etc. And then he's gone forward to say that we need to create a small group, etc., etc. So I think it's very relevant and important for not just India, but for the entire world. I can, if you, I'll just take a moment, I think, and I'll leave it to the other fellow panelists. NASSCOM, which represents the which is the Association of Software Companies, is already looked at this aspect. They're looking at it from a generative AI perspective. I think AI, to my mind, it's been in existence for many years now. So we've moved to the next levels, where you can be having the systems write the code, etc. So I think their guidance document, which came out a couple of months ago, is very relevant, and it kind of looks at, and I can just read quote unquote, that they're looking at how AI is going to help in all fairness in all places, but they've looked at how it will aid mitigation of following harms, and the harms that they talk about is infringement of intellectual property, privacy harms, propaganda of harmful social, economic, and political biases, and so on and so forth. So what I'm trying to say is, I'm trying to draw an analogy to a fact that what we are also thinking in terms of not just the EU proposed regulations, but the government, the private sector, and the industry bodies are already on it. And I just narrated a few stuff. And then this document is a very basic document. Of course, it's still in the initial stages, but I'm highlighting this for the fact that the industry, the government is all very serious about this piece, because this is here to stay. It's not going away. And we discussed yesterday on a lighter note. You mentioned lawyers need not worry. We are not going away, because that was my worry actually. Are we just going to be replaced by artificial intelligence, generative ones particularly? And I think the hint you gave me was Advocates Act requires physical person. So that's going to help us. But ultimately, I think that is the point. And these guidance document talks about guidance from a researcher perspective, from a perspective of commercial and non-commercial use, and so on. And then it talks about themes like reliability, safety, etc., and etc. So I think the world is thinking on the same lines. We are not excluded from this ecosystem now, and I think we all need to fall into place and get used to working on AI systems and adapt ourselves to how correctly we do it without infringing privacy and, I would say, copyright for now, and maybe other intellectual property concerns.
Thank you very much, Vineet. Lakshika, you are sitting here, but you're working for a French IT powerhouse. So very interesting to see your perspective on this.
Thank you. Although a disclaimer here, these are going to be my personal views, not the views of my company. But yes, surely, you mentioned earlier and pointed out very well, most of these regulations or laws have a Brussels effect. And we've seen that extremely impactful with GDPR, and how, many countries then had to, enact their own equivalent of that, or at least catch up with how they would cope with GDPR situations in some form or the other. And I think a similar spillover effect we see here. Of course, from an organizational perspective, the answer is pretty simple. As you mentioned, we are a French organization. We follow the gold standards, whether it was for GDPR or for the new act now. We already sort of have geared ourselves up for that. But how I think this has serious ramifications in the way we do business. And when I say we do business, I think business is not just how we sell or how we interact with our customers, but it starts all the way from how we build what we build. We build solutions, services, products, and so on. And it starts at the level of creation. What I mean when I say creation is the fundamental thing, let's say for an organization working in, just to give an example, let's say the software space, how you code, because you now have, systems that, like the Copilot, that allow you to sort of, it's pretty much for people who have not had any coding experience. It's almost like when you type something onto a Google search bar, it preempts reading a few alphabets, what you would want to say, or it preempts a phrase. Similarly, if you're a coder or you're a software coding personnel and you start to code, there are AI systems that will preempt lines of code that need to go into the program that you're writing. Now, the problem with that is that up till now within organizations, you had a certain guidelines for coding. You had open source measures, compliances, you had checks and bounds for any third party proprietary code getting creeping into your code and things like those. But when you have systems that preempt lines of code, how do you ensure that the ownership, the intellectual property rights, infringement issues, those are the things that don't creep into your code. So what I meant when I said it impacts business at all levels, there's a whole chain. So first you build products, services, solutions, then how you sell them, how you take them to market. And the same goes for when you source a lot of stuff from your vendors. How do you ensure that their practices are such that they're ensuring what they give you is kosher enough for you to then onward distribute, and nothing from the ecosystem which is not owned by the company has seeped into it, and so on. So one is on the ownership bit. Then the kind of data sets that are being relied on by AI systems, are those data sets removing any biases in them? Have they been checked for that? What are those data sets leaning towards in terms of these could be, well, racial biases, these could be other human rights that we're talking about. So all of these complexities are now into systems that are being created not just by humans, but with AI intervention. So even if you're using AI only as an assistant for prompting into what you're doing on a day-to-day basis, you run the risk of actually having to go through all this. And then, of course, when you move on and you take those systems to your customers, how do you manage questions around liabilities? Are you able to give the kind of warranties that you could back when you didn't have AI interventions creating those stuffs? Are you able to take on the kind of obligations? Because using those solutions, your customers are going to further build on top of it. We don't know what's going to happen after it leaves your premises. But again, having said that, I think locally, coming back to India and Indian regulations and how we see that evolving, I think India is not sort of catching on to it, I would say. Yes, it does have a Brussels effect, but way back in 2018 was when, for the first time, we already announced a national strategy for AI. And that's been sort of the route from where we now see, whether it is the NASCOM led mighty initiatives, or many others coming from tech, which is the technology, engineering and communication standards being released, which are not mandatory, but these are sort of they make a recommendation on what you can and cannot do. So we are seeing a lot of momentum. Well, I've sort of took notes, and here's a whole list of things that locally at the government level we are doing to be able to regulate what we do. Because in 2018, when we announced the national strategy for AI, the purpose and the underlining message behind that was AI for all. That's the message that Niti Aayog gave. In fact, it's called AI for all because it doesn't just talk about a couple of things like generative AI, which create more sort of conundrum in the space, but it's also talking about a lot of issues which are connected with human rights, with democratic rights that are vested in individuals, and how AI will impact those. So I think that is sort of the pillar or the underlining principles with which most of the regulations in India are being looked at or in the AI space, at least. Of course, we can go deeper if time permits, and I have a whole list here. I can talk more about it, but over to you on and probably Nirupam to add more on this.
Yeah, exactly. Thank you very much, Lakshika. So, Nirupam, we heard from two IT superpowers and we heard about the NESCOM, but I mean, and everybody knows, okay, this will affect the IT companies because they have IA systems and they implement them for someone else and they are subcontractors to a AI system producer and so on. But what about the other sectors? The same headache, or how do you feel about this? Is it coming to you? And as a GC, are you ready to tackle this, or are you where are your stance on this?
So I think Vineet said the statement like every company is a tech company. So today that's hold true. So even if our focus is on other sector, and again Hero Group, I work with Hero Group. I lead strategy, AI, and legal part of Hero Group. So the good part is both AI and legal are theirs together. So and a lot of things which people, the regulators, especially the lawmakers, think they come with the history of the legal systems and how they have developed law. Whereas technology and the technology folks come with more from a path-breaking perspective, something which has not been done before, and you're trying to create new technology. So all these new technologies create a new level of challenges and also make some of the laws redundant or obsolete. So what we are looking at from other industry perspective is two things. So we are creator and user. So if we are using Microsoft Office or Office 365, now Microsoft 365 or Google Cloud platforms, so we are users of artificial intelligence by default. So it's not like we are not using. And if you are using OpenAI ChatGPT, then again you are user of artificial intelligence, whether you are creating a response to a customer email or whether you are creating an image or content for marketing. So all these again have implications on us, and again how we, for our customers as well, because again it's going to them. So the second part is if we go back, a step back on the law perspective, I think there are some very similarities and some very dissimilarities between EU and Indian approach. The similarities is again, I think both the EU Act as well as Indian legal framework starts with the question, which is, where is our Google? Where is our Facebook? And essentially it's thinking that kind of, are we losing out in the digital technology race to American companies and Chinese companies? Because only these two countries have their own version of Google and Meta and every other thing. So we asked the same question, where is our Google? So, and I think EU's law, GDPR again had the same question, starting with how to stop all the data and the American companies mining European data and making themselves rich. But we also had very different, we are in a very different stage of economic development, whereas European Union is generally a developed area. India is far lower on that benchmark in terms of per capita income and the kind of poverty that we have. Yeah. So again, the focus of, and we made some mistakes along the way. One of the big mistakes I think we made from Indian perspective was in the drones law area. So for drones, and we kind of started with saying, oh, China is creating drones, and we just banned it. And we said, no, nobody can make drones, blah, blah, blah. And we realized we actually lost the big battle because everybody in India was importing drones from China because we kind of prohibited Indian industry. And that was a big rude awakening. And then again, we reversed it. We said everybody can make it. And even you can fly near the airports also, provided you have certain types of drones and with certain power and capacity. So we realized that, not allowing technology makes a country backward. So and again, and that we approach, see in the Data Protection Act, which got the parliamentary and the presidential assent this month itself, and is a topic of hot debate. And this was the fourth iteration. So we went back and forth on that law, where we said, let's stop, and copy GDPR. To saying no, we can't do that. Our industry will get killed. So let's focus on industry. Let's make digital economy a $1 trillion economy. And if we want to make a $1 trillion economy, we need to keep the door open for startups to exist. Because if we put too much regulation, startups will all die. So I think Indian approach is again very similar in the EU part, in the artificial intelligence space. Is we don't want to kill the startups. We don't want to kill the SME segment. We want to create a vibrant economy there, and that's where we are looking at a much more flexible approach. And again, of course, Lakshika has a lot of list here.
I wanted to just add to what you were saying about this. So it's very interesting if you look at how countries are trying to look at AI. countries like China totally want to regulate it, and much like their other regulations. US is more market driven. But I think the underlining tenets remain the same, and for AI, they put it very well, which is the FAT principles. Fairness, accountability, and transparency. And I think even for India and the Indian regulator, those are the underlining principles. By the way, I just want to bring to everyone's attention that India and EU, they actually signed off and established a Trade Technology Council in May 2020. And as part of that, and this is the first EU India Trade and Technology Council, as part of that, both of them are committed to and have taken upon themselves to look at AI from a trustworthy sort of perspective and angle. So I think for India, it's very interesting because there is the example of hugely regulated China kind of perspective. There is the EU collaboration where we are looking at trustworthy AI systems. And there is a very market-driven US perspective on how AI, and if at all it should be regulated and so on. But the kind of underlining tones that we are seeing, and I'm just reading into some quotes by various Indian ministers at various forums. As recent as April or May of this year, the communications IT minister said that we would not do anything which regulates the growth of AI. Of course, we are talking about regulating AI systems, which will be slightly different from regulating growth, research, applicability of AI. That is not something that India is planning to do, at least in the near future, as quoted by the government. Again, of course, we are yet to see, and we see that a lot of initiative is being taken, whether it is establishment of CORE, which is Center of Excellence, again, as part of suggestions by Niti Aayog, where they have also established ethics councils, which will sit on top of each center of excellence for research and analytics in AI. And, even if we are talking of applicability and research, we are also keeping track, or somewhere it's all happening with the background of ethics and those sensibilities in mind. It's not happening in isolation.
Thank you. Before I ask Vineet one more question, is there any question from the audience to these? I have a very esteemed and very knowledgeable panel to the left of me. So any questions from the audience to one of our panelists here? Good, I can see you all waiting for lunch. Then Vineet, before we have lunch, we have what we talked about today, the EU AI Act, we have GDPR, we have the Foreign Corrupt Practices Act, we have the Trading with the Enemies Act. All of these, obviously, when you look at them singly at what they're doing something, they want to do something good, they want to regulate an area that needs regulation. But you can also argue that is part of a trade war going on. The Europeans trying to get, make the American IT companies small, the Americans trying to get the German car manufacturers out of some areas, and so on. So is it worrying? Is this, where's the end? Or is this really good? Or do we have to live with the bad aspect of the good aspect of regulating stuff?
I think Lakshita talked about, there are a couple of principles, and we know, particularly in AI parlance or in that reference, fairness, how does it impact humanity, etc. So there are larger issues to my mind. It seems it's part of these continental wars and so on and so forth, which is okay. But I think, to my mind, there are larger issues. It can do great good to the humanity, but at the same time, it comes with a lot of risks. And therefore, AI cuts across sectors now. There are great sectors like healthcare, etc., where it can do real good. And then there are other sectors which will just benefit. So therefore, to my mind, I think it's not just about trade wars. It is also about the fact that we need some form of regulation for sure. I mean, what we are seeing in the US in terms of the GitHub pilot litigation, you have the open source community now come forward and come up with something. I know I'm not following that litigation, but I suppose a new version of claims has to be filed at this point in time. But the larger issue to my mind is, how do we kind of bring some minimal regulations and see how do we create. And I like this piece around high risk, low risk, etc. And I said this to you yesterday as well. So I think that's the focus, and we should look at from that perspective rather than just about how Europe is trying to take the lead and so on.
Lakshika, is it too expensive, or is it can't be expensive enough to protect democracy? What's your view?
Sorry, expensive?
Yeah, compliance with all of this.
Okay, this is again not an organizational view, but I'll say this, that even when GDPR came into fray, many organizations found it really tough to be compliant, and therefore they saw it as a cost issue, they saw it as a resource issue. But some of these things are already out there. If you close your eyes to it, it's not going to go away. Once you realize that they're here to stay and you gear your practices around that, you build your processes keeping all of that in mind, I think it's not going to be just a cost issue. Like I mentioned earlier, whether it is the government or an organization which pretty much works in a same way, it's after all run by humans. You have to see what is the background behind it. Are you able to protect basic human principles, basic natural justice principles? Are you able to remove biases, whether it is from your interactions or from how you use AI systems and so on and so forth? It's not going to be a merely cost issue, and I don't see it like that.
I think it is going to add to compliance costs for sure. We discussed the Data Protection Act the other day, and that's in whatever form that is coming in India. So that's a cost as well. Who bears it and how it goes down, we don't know. But at this point in time, but it's a much needed one. So it's going to surely be a cost for sure.
So I guess the problem, at least I can see, is that we are trying with the GDPR, with the EU AI Act, we're trying to protect the young generation who believes that freeware is free and there's no risk attached. And we know, being a little bit older, that nothing comes free in life. There's no such thing as a free lunch. So therefore, I believe, walking in my consumer shoes right now, that I think there's no other way. We have to do it. We have to make sure that everything that will be technically possible has to be under the law.
Absolutely, and it's about the values you stand for. Whether and forget AI, whether it is data protection or it is sustainability issues or it is ethical issues, everything comes at a cost if you literally sort of break it down like that. But then you have to, as an organization or as a nation, even ask yourself, what is the value that you stand for? Are you not investing in more sustainable initiatives? Well, that is for the larger good. It's not just because it's a cost, I'm going to still use plastic bottles because, they're much cheaper. But everyone is, right? So it's about what is good for humanity.
Again, I would add a caveat here is that some of the things in the current format, and again, it predates the generative AI boom that has happened, is somewhat impractical, if I were to use that word, especially asking companies to share their data sets. That will be a big issue. Second is, again, ensuring non-bias in the data sets is again going to be a serious issue, because we have the data set that we have. We cannot generate, even though a lot of people say we generate artificial data to reduce bias, but I think that's not really going to solve the issue of bias, because ultimately AI systems are learning from the data, and if you make generalized data, then there's no learning. So we have to see through it. Yes, it's a good thing to look forward to, but I'm sure that we have the Italy example, and we also have the Japanese example, where the Japan have said that there's no copyright law if you want to create a generative AI model. So which is I think which is the direction. I see again, European has a legacy of copyright law and other things, but I think again, my view, copyright law will get obsolete. That's the view I take it, because ultimately the whole thing is the definition of intelligence is going to be changed, and the creative part is going to be very, very different. So But there's a bigger thing which I think Lakshika executed too is the threat to humanity as a whole. I mean, what if we talk of singularity, if the artificial intelligence systems become more powerful than the humans and the state actors themselves, then who's going to control, and how do you control something which is more powerful than you yourself? So these kind of questions, and again, there's a responsible AI approach that I think a lot of people talk about without really understanding how to implement it or how to go about it. But again, it's a good thing to have a talk about it. It's a good thing to have a document which people can discuss, debate, think through, and again, both from the industry and the legal and the regulatory perspective. And this is, I think, one of the great gift to the world from European Union. And again, China has moved a step ahead and they have actually implemented. This is still not an implementation. This will take some time. As you said, 1 year. I expect more than 2 years. But anyway, we'll see. But China has already implemented a lot of ban the biometric and stuff. So which is again interesting. China moving fast on this. Maybe it's just for PR thing. I don't know. But they are again. So there's going to be a race both on the systems and the regulatory side catch up. So we will see how things go.
Super. How lucky we all are that in this time and age we are allowed to be lawyers, because we are at the very beginning of this next wave, and it's going to be very interesting to see in 1 year when we sit here again and discuss this topic what the new technologies will be and where the law will be. And we always have to do a catch-up game. We're never going to overtake these IT guys. There's no doubt about it. So with this, I would like to close this panel because I can smell the food already, and I'm sure you can too. Was there one more question? Or? Okay, there's one more question. Sorry, we have to go for it.
My question was for Ulrich. They've rolled out the Digital Services Act today itself. So how do you see the EU AI Act, the Digital Markets Act, and the Digital Services Act being able to ensure ethical innovation and deployment of AI in the EU? And as you said, there's a Brussels effect, so at least it will have an effect in the US. How do you see the three of them working together?
It's not just the three of them, it's also GDPR, so it's four of them. And unfortunately, they all stand next to each other because they have different scopes. GDPR is protecting personal data. The EU AI Act is protecting safe and legal AI systems. The Digital Service Act is protecting and making sure that digital services are, again, clear, precise, you can see what's behind it and what's input, what's output, and so on. So it adds another layer of compliance, and it's not you have done one, EU Digital Services Act. You have to also look at the EU AI Act, you have to look at the GDPR, because all these fines stand next to each other. And unfortunately, you can catch 3 fines with one act, and that's what's so worrisome.
More fun for lawyers.
More fun for lawyers, yes. As I told Vineet, we all in each of our jurisdictions, we have a law saying that if you want to provide legal advice, you have to be at the bar. You have to be a member of the bar. As long as the bar is governed by lawyers, no AI will be allowed to the bar. So I'm sleeping very soundly every night. So I'm happy. Thank you.